Hello, everyone. Today we're discussing constitution and constitutionalism. And basically, we're trying to find out what are the differences between these two concepts constitution on one hand and constitutionalism on the other hand. We want to find out what do these concepts entail and how are they useful for us in the conversation around government. Now, many people confuse these concepts. They in fact they use them most times synonymously. All right, but these concepts are different concepts because they have different meanings. While constitution is a noun because it has to do with a document, a thing. It is something, you know. So it is a noun. Constitutionalism, on the other hand, is something else. More of a verb. It's an action, you know, that involves action, involves perception towards the constitution. So they are entirely different things, and it's important for us to understand what these concepts mean. All right. The two concepts, anyway, are very useful concepts in discussions around democracy, around representative government, around good governance, as it were. All right. So this presentation would help us to understand these concepts and highlight some of the significant aspects of these concepts. Now, what is the Constitution? We would find several definitions of these concepts, in literature, in dictionaries, and wherever else that this conversation comes up. People have tried to ascribe meanings to this concept. Some of the definitions are the ones given by Strong, who said that constitution is a collection of norms or standards according to which a country or a state is governed. All right, a collection of standards, collection of norms, where, on the other hand, also define constitution as a condition or conditions for the exercise of legitimate power. So what conditions are necessary in order to exercise legitimate power? Under what circumstances can legitimate power be exercised? Who shall exercise such political power? And how shall they exercise power, and the limits of these powers, or within the limits of the powers? So these are some of the definitions that give us an insight into what constitution as a concept entails. So generally, constitution is a document or a collection of documents that specify how a state should be administered, should be governed, or should be run. Okay, and of course, it's a very fundamental aspect of modern political societies or political system. You know, there are several sources of a constitution. The first source that we have here is the organic laws, and organic laws are said to be rules that are made by ordinary legislative proceedings or procedure. Of course, aside the constitution, there are also laws that the legislature makes, to meet certain need or for certain situations. Those laws are not a part of the constitution. They don't constitute the constitution, as a document. But these laws are a source of the laws that govern the states. They are a source, of the constitution as well. Even though they are not a part of the constitution, but remember we said constitution is a body of norms or rules that guides how people in the state are governed or how a state is administered. So these organic laws, for instance, the Electoral Act, it's not a part of the constitution, but it is a document that is binding on every individual in the Nigerian state. All right. The second source are judicial decisions. There are court decisions that are made on certain very, very important cases, of maybe national significance or even municipal significance. And these cases, the verdicts that are given on these cases provide some reference points, on how such similar cases can be administered and can be interpreted in the future. And of course, they can also serve as the basis for some rules, some norms that will also regulate and guide how society is administered. All right. Philosophy is another source of a constitution. Of course, we have talked about some of the ideologies of Montesquieu, separation of power. Some of the ideologies of Aristotle, Plato. These ancient philosophers and even philosophers that even philosophize today somehow argue certain very important points that find their way into the Constitution. So these ideologies are not also a waste of time, because the ones that border on how people are managed, how society can be more effectively administered, they find their way somehow into the Constitution, and they form part of the laws that govern society. Of course, the separation of power doctrine was a doctrine by Montesquieu, but today it is a part of the constitution of many modern societies, in the world. So philosophies are also a very important source of the constitution. Customs, conventions, the practice of the people over time, what the lifestyle people are used to, all right, also form a part of the constitution, because even though these are not formal rules, you know, they are as effective as constitutional laws, because they are used over time, they are practiced over time, and as people practice these norms, these customs, they become accustomed to them more. Their behavior is constrained or limited by these norms and these culture conventions that they practice. And in fact, in some other cases, some of these norms find their way into the constitution. For instance, in Nigeria, we have the Sharia laws, which are a part of Nigerian constitution. The customary courts, Sharia courts, and so on and so forth. So these conventions or norms and beliefs, traditional beliefs of individuals, find their way into the constitution somehow. In certain cases, experience is another very important source. The experience of a state or a nation, a country over time, the history that they have about their state, can provide some basis for some of the clauses or provisions in the constitution. Of course, we had several years of military rule in Nigeria, or we have had several years since 1960, before 1999, when the latest democratic rule began. That history of military rule for over 30 years, necessitated a clause in the Nigerian constitution that is called the anti-military coup clause. That says that no part, or group within the Nigerian state can shall attempt to take over power from the government, or shall attempt to unseat the government of the Federal Republic of Nigeria. So that is a clause that was a consequence of the history, the experience that Nigeria has had of incessant military rule. So experience is also another very important source of the Constitution. So we have highlighted 5 sources of the Constitution: organic laws. We also talked about customs, conventions. We talked about experience. We talked also about judicial decisions and philosophy. All right. So these are 5 sources of the Constitution. And it's important that we understand this, because particularly in Nigeria, these are the sources of the laws, the rules that govern our society as Nigerians. Now, how are constitutions classified? There are 2 broad classifications of constitutions. There's the written and unwritten constitution, and there's the federal and unitary constitution. The written and unwritten basically are 2 sides of the same coin. The written constitution, refer to laws or rules that are contained in one single document or in a few documents. So maybe not one document, but in a few documents. These rules that guide the behavior of states are contained, in these few documents. And examples of such states, or states that use such kind of constitutions, and Nigeria and the US. All right, in Nigeria we have a constitution. In the US there's also a constitution, but we have other laws. We've talked about organic laws. We've talked about um, judicial decisions. These are other aspects of the Nigerian constitution that might not be written inside the book itself. All right, the unwritten constitution are derived from statutes, from customs, conventions, all right, that are practiced over the years. And of one particular characteristic is that they are not contained in a single document. They are contained in several documents, which of course can be exemplified in the Constitution of Britain. Okay, so that is one major difference between the written and the unwritten. The unwritten, many people think that when you talk about unwritten constitution, it means that the constitution is written in the hearts of the people. That there are no documents that prescribe what is required. All right, but people have in their minds a knowledge of what is required of them within the state as regards to how to behave. But that is wrong. An unwritten constitution is not necessarily unwritten literally, but it just means that it is not contained, in a single or a few documents. It is contained in several documents, which constitutes the constitution of such a state. Now, one characteristic of written constitution is the fact that they are more rigid. They are difficult to amend, because of course they are together. They are codified in a single or few documents. So it takes a longer process to amend such constitutions. And that's why they're regarded as rigid constitutions. So written constitutions are naturally rigid, in the sense that they are difficult and they involve very lengthy amendment procedures. And the reverse is the case for the unwritten. Unwritten constitutions are easily amended, because they are not as rigid as the written ones. They are more flexible and amenable to change. The unitary constitution are constitutions that are practiced, in countries where the central government, or where power is concentrated in a central government. So in states where you have central government being supreme, these kind of constitutions do not give power to the other units of government. Remember, we talked about the fact that federal system, in a federal system, there's separation of power in the sense that other units of government have their functions prescribed by the Constitution. So the Constitution tells every level of government what is required of them. But in the unitary constitution, the central government has all the powers, and the central government only can delegate to the subsequent units, or subordinate units, the powers that they think they need for certain activities, over a certain period. And of course, they can revoke such powers as well. So the unitary constitution is one where the other units of government do not have their functions prescribed by the Constitution. All right, but power is reposed completely in the central government. That is the unitary constitution. But the federal constitution is one where power is decentralized. The central government has its functions. Other units of government also have their functions, and the Constitution prescribes all these functions that these units are expected to perform. All right. So that is the major difference between these two classifications, written and unwritten. One is rigid, the other is flexible. One is codified in a single or few documents. The other is contained in several documents. Unitary power is concentrated at the center. There's no provision for the functions of the other units of government, or there's no allocation of power to the other units of government. So the central government has the prerogative to decide whether they want to create subsequent units, when they want to create it, for what purpose, what amount of power will be allocated to such a unit of government, and so on and so forth. All right. Whereas the federal constitution is one where power is shared among all the units of government, so that every unit understands their responsibility within the state. Now, the contents of the constitution include, these are things that the constitution must contain. All right. A constitution must contain these things we're going to mention now. A preamble. A preamble is basically the statement that opens the constitution. You know, we the people. It usually begins by we the people of so 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 and so state, based on so so and so reason, give ourselves these rules to govern, us within this state. So that is the preamble of a constitution. And the preamble basically states the authority upon which that constitution is made. And the authority of a constitution is the we the people. We are the ones who unanimously agreed that these laws will be binding on us. All right. So every constitution must have a preamble. Every constitution must also spell out the structure of government. Is it a unitary structure? Is it a federal structure? Is it a confederal structure? Is it a military structure? Right? Of course, military governments do not run with constitutions. They rather operate with decrees. Okay, but every constitution must prescribe what is the structure of government. How many levels of government exist. What is the how do these levels interact with one another. So the structure of government is one important content that must be present in every constitution. Distribution of power is another one. Distribution of power. How is power distributed? And of course, this also throws our mind back to the organization of government. All right, executive, legislature, judiciary, the organs of government. What are their functions? How do they interact? All right, is it a parliamentary form? Is it a presidential form? So that is this must be prescribed by a constitution. So once you pick a constitution of a country or a state, you should understand, or you should be able to know already what system of government is in operation. What is the organization of government within that state, as well as the structure of government. All right, the rights of citizens and their duties. The constitution must also contain the rights and the duties of citizens. All right, the functions citizens are expected by law to perform, and we looked at some of them in our previous lecture. Being able to vote and be voted for, paying taxes, promoting and defending the image of the country, not engaging in any activity that will tarnish the image of the country, defending the country when the need be, and so on and so forth. Those are the duties of a citizen. All right, the rights, right to life, freedom of expression and conscience, owning property, and all of those 10 rights that citizens enjoy. Okay, the procedure of amendments is another content of the Constitution. The Constitution must spell out what is the process of amending the laws that are within the Constitution. Whether it is a flexible or a rigid Constitution, there has to be a formal process of amending such laws. So these are the contents of the Constitution. A Constitution must have a preamble. It must spell out the structure of government. It must spell out the organization of government or the distribution of power. It must spell out the rights and duties of citizens. And of course, the amendment procedure as well. So any constitution that doesn't have a preamble, for instance, is not a constitution. Because the question is, on what authority were these laws made? Who were the people who agreed to come up with this body of rules? A constitution cannot omit the distribution of power within such a state, because it will mean that the organs of government do not understand how they function or how they interact, or how they interrelate with one another. So these are the contents of a constitution. Let's talk about constitutionalism now. Constitutionalism. So basically, this concept we have said before is a verb. The Constitution is a noun because it contains laws, rules that guide behavior. But constitutionalism is a verb, which refers to limited government. That essentially is the idea that constitutionalism portrays. Limited government. Limited government in the sense that not that the government, is limited because it cannot carry out activities that it's supposed to, but the government is not arbitrary. The government cannot just do anything anyhow, because there are laws that limit the power of government. So constitutionalism, it portrays that idea of a limitation on the power of government, on the excesses of government. So the rules, the laws, the principles in the Constitution limit excessive power of government, and that's what we mean by constitutionalism. And of course, such powers are limited only when the government is obedient to the Constitution, right? So, if, for instance, there are laws that are supposed to regulate the behavior of an individual, and the individual doesn't obey those laws, it means that the laws doesn't have any effect on the individual, right? So the laws can only accomplish its effect on the individual when the individual is adherent or obedient to those laws. And that is the same thing with constitutionalism. A limited government can only be achieved when the government is in compliance or is obedient to the principles, the laws that are listed in the Constitution. All right. So, in essence, what we're saying is that constitutionalism has to do with obedience, adherence to the rules, the laws that are listed in the Constitution. All right. That is what constitutionalism is: adherence, compliance, obedience to the provisions of the Constitution. As simple as that. And of course, you understand that even though every state, has a body of laws that specify how, the state should be governed, or that specify the rules that regulate the behavior of people, not every state is obedient to those laws or the rules. Not every state is constitutional, So, and that's why we are saying that the two concepts are different. A state may have a constitution, but might be very far from constitutionalism. All right, and of course, it doesn't matter how nicely crafted, how good, how effective, or how efficient or beautiful the Constitution is. It doesn't guarantee that it will be adhered to. All right, so the point we're making is that a constitutional government, a limited government, is one that is obedient and adherent to the laws, the principles that are provided in the Constitution. And the question is, can you think of any unconstitutional states or governments? Of course, there are quite a number of them, and you can come up with them off the top of your head. Maybe you should list some of them, and we can interact after the presentation is over, on some of those states that you have listed that you think are unconstitutional. All right. Now, these are some of the features or characteristics of a constitutional government. There's respect for rule of law, there's liberty, there's separation of powers, there's press freedom, there's independent judiciary, there's tolerance of opposition, there's accountability, responsibility, responsiveness of government as well. All right. There's also protection of citizens. So these are all characteristics or features of a constitutional government. So any constitutional government that doesn't respect the law is not constitutional, or that doesn't separate powers, depending on the kind of constitution it is, whether it is unitary or federal, that doesn't allow press freedom, that doesn't, allow the judiciary to perform its functions independently, or doesn't tolerate opposition. So all of these are characteristics or identifying marks of a constitutional government. All right. Now, how do we know that the constitution is effective? What are the conditions, that must be satisfied in order for a constitution to be effective? Effective in the sense that it is able to be binding. Individuals can obey without so much force. They can comply with the principles of the constitution. The first condition is that the constitution should allow for changing circumstances. So it should not be so rigid, or it should not be so insensitive to change. All right. I think there's a typographical error there. The constitution should allow for changing economic and social circumstances. All right. It should not be. It should not. It should be susceptible to change. That's the point we're making. All right. Of course, the custodians. The second point is that the custodians of the Constitution, those who are charged, the government, basically, those who are charged with enforcing the laws, must also comply with the same laws. So for instance, in Nigeria, we see law enforcement officers breaking the laws that they ought to be upholding or implementing, executing. They themselves are the ones who break these laws, and that is not very good. So that's already a recipe for disaster, because once law enforcement officers are breaking the laws, it means that everybody else is free to break those laws. All right. So the custodians of the Constitution must abide by the dictates of the Constitution. Okay. The Constitution must also satisfy the needs of the citizens. The citizens' needs must be met. People must be included. The minority groups must be catered for in the Constitution. And that way people feel that they are involved, and of course they feel that they own the Constitution, is their property, and so they can comply with such rules. Okay, I've talked about minority groups, but that is also another condition. The rights of the minority should be protected. Of course, it is said that the majority have their way. The majority the majority carries the day. Which is ideal in a democracy. But that does not mean that the minority should be lost as well. The minority should also have their say, even though the will of the majority will be done at the end of the day. But the minority should not be deprived of having their say in the matter. All right. And finally, a good and effective constitution, must be able to reconcile the opposing interests of the people. Of course, in a state, there are so many interests that need to be met. There's so many concerns that the people have. A good constitution must be able to harness all these interests and synchronize them in such a way that there is one objective, that the state intends to accomplish. All right. So these are the characteristics of an effective, or the conditions for an effective constitution. Once these conditions are in place, then there's a very higher probability that individuals would comply, that the government will be constitutional, and that people will also be constitutional in compliance with the laws that have been made. In conclusion, we have said and identified that constitution and constitutionalism are entirely different concepts. All right? They're entirely different concepts because they have entirely different meanings. Why constitution, are the rules that govern society. Constitutionalism refers to adherence to these rules. Okay, and not all states or governments are constitutional, even though they may possess a constitution, but not all states are constitutional. All right, the limits in governance, or we say constitutionalism is limited government. The limit, in the government is provided by the rules. The limit is achieved by the rules, by the norms that check the excesses of government powers. So the Constitution is expected to limit arbitrary rule or prevent arbitrary rule by the government. And so once it is achieving that purpose, it means that the government is a constitutional government. All right. Beyond beyond crafting a good constitution, what is more important? What is more important is adherence. So if we are asked to do a scale of preference, constitutionalism definitely will come at the top. Even though without a constitution, there cannot be constitutionalism, because constitutionalism is adherence to the constitution. So even though the constitution must exist first before we talk about constitutionalism, it appears that constitutionalism is even more important than the constitution itself. All right, so those are the issues that I think are very important for us to take note of in this conversation. We're going to end the presentation at this point. If you have questions or comments, we can take those and continue the conversation. But thank you so much for listening, and thank you for your time.